The European Data Protection Board recently adopted its highly anticipated opinion on the processing of personal data in the context of AI models. The opinion addresses 4 questions based on a request from the Irish Data Protection Commission. It covers processing at both the development phase, which covers all stages before any deployment of an AI model, and the deployment phase, which covers all stages relating to the use of an AI model and may include any operations conducted after the development phase. First, the opinion considered when and how can an AI model be considered anonymous. The opinion states that AI models trained on personal data cannot automatically be considered anonymous and sets a very high bar for this. The documentation relating to compliance and accountability will be important for assessing whether an AI model is anonymous. Next, the opinion addresses how can controllers relying on legitimate interest as a legal basis for data processing demonstrate its appropriateness in the deployment and development phases. The opinion acknowledges that there is no hierarchy of legal basis and leaves the door open to rely on legitimate interests. However, it sets quite a high bar to rely on legitimate interest as a legal basis for processing personal data in the context of AI models, in particular emphasising the balancing assessment that needs to take place where the controller's interests are weighed against the fundamental rights and freedoms of data subjects. Having robust compliance documentation in place will be important in order to rely on legitimate interests. Finally, the opinion considers the potential consequences if personal data is unlawfully processed during an AI model's development phase. When there is unlawful processing and the finding of an infringement, supervisory authorities may impose corrective measures, such as ordering controllers to take actions in order to remediate the unlawfulness of the initial processing. These may include, for example, imposing a temporary limitation on the processing, erasing part or all of the dataset that was processed unlawfully, or even the AI model itself. Measures taken to remediate the unlawfulness of the initial processing may also be taken into account. The opinion is intended to be a framework for competent supervisory authorities to assess specific cases and underlines the importance of case-by-case assessments being carried out. It remains to be seen how it will be applied in practice. It also does not analyse a number of key topics which are also important when assessing data protection requirements related to AI models, namely processing of special categories of data, automated decision-making, compatibility of purposes under Article 6.4 GDPR, data protection impact assessments, and data protection by design. No doubt there will be lots more to come on this topic.